All right, guys, how are you guys doing here? Let me get the breaking news sound here.
Breaking news! Breaking news!
All right, let me just make sure that we are going live out to the people and we'll get the song. Yep, we're going live. Okay, so what we are going to be talking about is we got a new decision in. We had a decision on Friday in the Bonta case, which basically said that magazine limitations is unconstitutional, and the Judge Benitez.
Well, wait. When you talk text and tradition, there were no magazines back when they had muskets.
Okay. Okay. So we got the decision on Friday. Stay on topic, Rich. No, seriously. We got that decision on Friday, and now we have another decision today from the left coast. This time from Washington State, and this time it's not a good decision. And it was basically in the case of BRUMBACK versus Ferguson, and the judge did not issue a preliminary injunction, but also did not say that it wasn't unconstitutional. And we're gonna go over a little bit of the case. We do have a huge announcement coming out in about an hour or so. I'm going to try to get through this pretty fast. That's why I was shutting Rich up a little bit. But basically, this is the federal challenge to the magazine ban in Washington State, which is known as, I don't know, it's known as Senate Bill 5078. They wanted him to find it unconstitutional. They did not. Senate Bill 5078 basically banned anything holding more than 10 rounds. And as we know, in California, there is a ruling against the same thing. But this judge did not agree, and we're going to go over the reasons why.
So were both these rulings out of federal district courts?
They're both out of federal district courts.
But different federal district courts?
Different federal district courts. This guy is a very, very anti-gun person, so I'm not surprised. So he cites a bunch of different things in here.
Not Bruin, I guess.
Yeah, okay. Go ahead, read this.
No, really? Okay. Following Bruin's, courts must ask two questions when considering a Second Amendment challenge. First, whether the Second Amendment's plain text covers the conduct targeted by the regulation. Second, if the conduct is covered, whether the government has demonstrated that the regulation is consistent with the nation's historical text and tradition of firearm regulation.
Yeah. All right. So he basically recognizes Bruin, but he...
And?
Yeah, we're going to get to that. And we're going to go down. So I just wanted to point out that he does recognize Bruin, but he uses some, what I call legal jujitsu to get around Bruin.
Yeah, there's got to be a lot of legal jujitsu to get around Bruin. And I guess he's the right man for the job.
Well, I'm going to try to go down to...
Because Bruin will eventually get us 50 state constitutional carry with reciprocity.
Okay, let me just say that the state tried to argue that that magazines are not in common use and they are dangerous, unusually dangerous. And there's a lot of evidence that that was presented by the plaintiffs. But read this statement.
The court is not strictly bound by all rules of evidence when considering a preliminary injunction. I never heard of that. But it quotes a legal case where it says, rather, evidentiary standards are relaxed to accommodate the urgency of obtaining preliminary injunction, which necessitates prompt determination
Right,
and.
You don't have to read all that.
Okay.
Okay, read from here.
The injunctive relief that plaintiff seeks is significant. They ask for the entry of an order enjoining defendants from enforcing ESSB 5078 and declaring the same to be unconstitutional. The product of the democratically elected Washington state legislature. If the court is to declare ESSB 5078 unconstitutional, it will not do so lightly. The injunctive relief is an extraordinary remedy that may be awarded upon showing that the plaintiff entitled to such relief cites a case. The court will not reduce the evidentiary rigor required for an injunction such that plaintiffs may obtain one by citing two TO articles found on the internet, not TWO, without explaining their academic and scientific worth of a historic accuracy. Holy freaking cow.
Basically saying that I'm not going to take anything that you give as fact, and I'm not going to consider a preliminary injunction because it's going to take a lot of work to prove that it's unconstitutional, and I'm not going to put in the work to do that at this point.
What a jackwagon.
What's up, Dark?
What's up, bud?
Wait, on 13. So further plaintiffs may not simply rely upon pre-Bruin case law to prove their case. Well, wow. Boy, this guy is good at legal jujitsu. The gravity of the relief requested and uncertainty of prior authority, Bruin's wake demands renewed analysis on rests upon reliable evidentiary showing. The court must insist that there is a historical record in order to make a determination on the meaning of the word arms. Oh my gosh, used in the Second Amendment.
Yeah.
So we don't even know what a gun is now.
No, here you go.
Specifically, whether arms includes magazines or large capacity magazines. See, blah, blah, blah. At present, the evidence in the record is insufficient to establish that plaintiffs are likely to prove that all large capacity magazines fall within the Second Amendment right. The instant decision is primarily the result of the plaintiff's inefficient evidentiary showing and should not be read to preclude contrary finding at trial on the merits.
Basically, that is saying that, hey, I'm finding it now, but this might not be, it still might not be constitutional, but I'm not going to worry about that right now.
Yeah, we don't really want to put in the legwork there.
It is pertinent to note that, however, that no party at this stage has demonstrated historical record adequately supporting their respective positions on the question of whether the Second Amendment covers large capacity magazines. How about the puckle gun?
There are numerous.
All right. Yeah.
Good.
Keep on going. I'm going to try to get to this.
Similarly, the court requires reliable evidence to find large capacity magazines in common use today for self-defense. Plaintiffs attempt to demonstrate the commonality of large capacity magazines for self-defense with tenuous evidence and citations to pre-Bruin authority. As discussed above, it remains unclear whether this finding is a factor of the Bruin test at step 1 or 2. However, the current state of authority suggests that it is at least worthwhile to consider state defendants for their part attempt to submit historical record. However, the history experts have unanimously Having found that the plaintiffs have not met their burden, the court declines to continue to Bruin Step 2, at which the government must then justify its regulation by demonstrating. So now there's still a two-step test?
No. What they're saying is step 1 of the Bruin test is text.
It's
Step 2 is
tradition.
tradition and history. So they're saying
Well,
that you haven't proven that the text covers magazines, so therefore we don't have to worry about like
wow.
tradition and history.
But in history, they haven't regulated any of this stuff. So
But
there is no history
they're saying we didn't get to that part.
because of text. So I've never heard this before. Okay.
All right. This is basically saying it's not against the Washington Constitution either. All right.
Of course.
All right. Here you go. We'll start from 3.
Washington courts presume the statutes are unconstitutional and place the burden to show unconstitutionality on the challenger. Citing the court case, the Washington Supreme Court has long held that the firearm rights guaranteed by the Washington Constitution are subject to reasonable regulation pursuant to the state's police power. Citing a case,
All right.
in the fact,
basically what that is saying is that the burden of proof is on the defendants to prove that it's unconstitutional and not on the state to prove that their law is constitutional.
wow.
Go from here.
Okay, from 9.
Yeah.
In fact, Washington Supreme Court has expressly distinguished the Washington Constitution from Heller's analysis. While Heller rejected the use of freestanding interest balancing approach to determine the scope of Second Amendment rights, we read the Washington Constitution's provisions independently of the Second Amendment. Whoa. In contrast to Bruin test, a Washington court considering the challenge under Washington Constitution must first consider whether the regulation is reasonably necessary to protect public safety or welfare and substantially related to legitimate ends sought, then balance the public benefit from the regulation against the degree to which it frustrates the purpose of the constitutional provision.
Okay, basically saying Bruin says we can't use the two-step test, but Washington State Constitution says we can use the two-step test, so we can rule that this is okay.
Wow. Given the lack of briefing on Article 1, Section 24, the court finds it would be inappropriate to issue a preliminary injunction at this stage. It is the plaintiff's burden to establish that ESSB 5078 violates the Washington Constitution. Plaintiffs failed to engage with the relevant standard for challenges under Article 1, Section 24. To grant plaintiff's request for relief at this stage would amount to a sua sponte injunction. On a scant record, the court declines to do so.
No,
Wow.
and basically it's saying like, they don't, this is all saying that they don't have to basically rule on anything else.
Constitutionally particular, okay.
Okay, we can start here.
Start here at 1.
Yeah.
Constitutionally particularly in light of the uncertainty of the Second Amendment.
Sorry.
Jurisprudence following Bruin, still the balance of the equities does not favor preliminary injunction. First, to consider plaintiff's harm. Even a brief deprivation of constitutional right causes irreparable injury. Law cases cited. The Second Amendment right is not a second-class right, according to Bruin and McDonald. However, the plaintiff's Second Amendment right is not so clearly infringed during the pendency of this litigation to warrant extraordinary relief of a preliminary injunction. See Winter, as state defendants and the Alliance highlight, ESSB 5078 does not prohibit the possession or use of large capacity magazines already owned. Gilroy may be prohibited from selling his existing inventory of large capacity magazines, but monetary injury is not normally considered irreparable.
Okay, what they're saying is that irreparable harm cannot be made whole by monetary means. So they're saying that the guy who owns the gun shop is not being irreparably harmed because it can be settled by monetary means because he has a bunch of magazines. And they're also saying since people are allowed to keep the magazines they have, they're grandfathered in, their rights aren't being violated just because they're not allowed to acquire any new ones.
Wow.
That's absolute just ridiculousness.
Yeah. Here we go.
On 10, although the import of the evidence to constitutional analysis is in doubt, under controlling authority, the court must consider the public consequences in employing the extraordinary remedy of an injunction. The evidence offered by the state defendants and alliance supports the denial of an injunction at the stage of litigation.
Basically, they're saying that, hey, since I'm doing the two-step test based on Washington law, basically what he's saying is that if I remove this, people might get hurt because people can get magazines. So therefore, I'm going to.
But people already have magazines.
I know. I'm just telling you what he's saying.
Rich, please don't try to make sense out of this. Okay.
All right. 16.
For reasons stated herein, plaintiffs have failed to demonstrate a likelihood of success on the merits and balance of the equities disfavors a preliminary injunction while litigation pending plaintiff's motion for injunctive and declaratory relief is denied.
All right. Now the next October 13th when they have to.
So the parties shall on. Well,
No, that's it.
Okay.
Basically, this is a preliminary injunction. It's not a permanent injunction or anything like that. So they're going to still argue that. But I think this judge got it wrong. I'm more in the camp of Benito's.
Yep.
Well, for sure. So part of his logic, don't get me wrong, there's a massive amount of BS and pretzel logic in there. He said you're not getting your rights infringed upon because if you own a 30-round magazine, you can still have one. But then in the next, paragraph, he's saying 30-round magazines provide such a high likelihood of danger and threat.
That's ridiculous.
Which one is it?
But they had also argued that gun shops aren't protected under the Second Amendment, which is total BS.
Wow.
There's a whole bunch of wow in there. So what you're going from a state right now, or prior to this law being passed, large capacity, or as any one of us on the panel here would say, standard capacity magazines are normal. So they took everybody's right and ability to have a magazine with greater than 10 rounds and threw it out the window. So now they're denying somebody's rights. This injunction would merely keep it how it was prior to this dumb law. But they're saying, no, these things are so damn dangerous, even though you can still have them. If you already own them, you're grandfathered in.
A preliminary injunction is to maintain the status quo, and this judge apparently doesn't think that's the status quo.
Yeah.
Well, in one breath, he's saying you're getting the status quo. If you own them, you can still have them.
Yeah, he is claiming that, so that is something there.
And the portion about the financial aspect, that one of the pieces to being granted an injunction or is any type of permanent or negative impact, whether it be financial or losing one employee, right? People have been granted an injunction.
But they can say that is can be remedied by monetary means.
Of course. Yeah.
Irreparable harm is if you can't be remedied by monetary means.
So this is just ridiculous.
Not saying I agree with it. I'm just saying.
No, of course. You're stating their their argument, which is
Yeah.
ridiculous. Somebody had said this isn't a judge, this is a
So,
political activist.
but he's claiming that greater than 10 round magazines are not in common use.
Well, no, that's what the plaintiffs were. No, the defendants were arguing that they're
Okay.
dangerous and unusual.
Dangerous and unusual.
The affray.
My carry gun has 10 rounds. The gun I pocket carry, every other pistol I own carries more than 10 rounds standard.
Yeah, my carry gun is 15.
20 plus 1, just stick it out of the waistband.
I mean, yeah, I don't, other than LCP2, I don't have a gun that carries less than 10 rounds.
Yeah, I have 1 or 2.
Yeah, and everything else, if it doesn't fit in my pocket, even if it did, it carries more.
Yeah, that's ridiculous.
No, okay. So I just want to bring up something. The injunction against the law is from a Washington state court. This is a federal court. So there are certain Washington state lawyers that are good, and there's certain and there's certain ones that are bad, depending on where you are in Washington state. Every federal judge that's in every district federal judge in Washington, and also the circuit court, is bad.
Wow.
So that's why you saw GOA go after this on a state level, because that gives you the best chance of winning.
But
yeah,
wow.
I mean, just look what's happened to Washington State over the last decade and some change. It has become one of the most anti-gun, anti-building, even with and I know we're not talking about gun building, right? But even if you provide any tool or support or any aid in any fashion in building an unserialized firearm, they're going against people. Like if I sold a jig to Washington State, they could come after me legally. Like they've gone so far past reasonable. This is crazy.
I own tons of 1911s. I just don't carry 1911s.
Well, also 1911s. I think my officer 1911 is 7 plus 1. That's 8 rounds.
So I actually don't own a metal frame pistol.
I have one 1911. If you could see, I like Glocks. I actually have a 10 round AK magazine as well.
Interesting. Yeah, I had a AK from the band era that I had to take a Dremel.
Oh yeah.
So,
Well, this was so that chrome and plum AK back there. I wanted a matching plum magazine so bad, and Arsenal K-VAR had a 10 round plum mag, so I was just like, got that.
All right, guys, that is it. Just wanted to go ahead. I just wanted to go ahead and talk about this really, really quickly. And
more tyranny coming to a state near you.
Yeah, in about 20 minutes or so, we have a big announcement over on John Crump Live. That's John Crump Live. I don't think you guys want to miss this. This is a badass product coming out.
Yeah. Huge.
I think you guys are going to really, really like. So tune in about 20 minutes over at John Crump Live.
Yep, we'll all be there.
And with that, we are out of here. You guys have a great day. Thank you for all your support. And one more thing.
Hold on.
The ATF?
Really quickly, don't lose all your guns in a boating accident. Load them bitches up, okay? It's never time to lose them in a boating accident. It's time to lose them. It's time to use them. Just saying.
All right. We'll see you in about 20 minutes. All right, bye.